The defendant's attitude was cooperative through the interview process for the preparation of the pre-sentence investigation report. Ms. Hawkins has served 345 days as of today's date of June 17th, 2026, for which she's entitled statutorily to credit against any sentence imposed. The family history: Ms. Hawkins was born on May the 22nd, 2000 in Brown County, Ohio, to Karen Sue Hawkins and Scotty Stanford Hawkins II, both of West Union, Ohio. She currently resides in West Union. The defendant has two biological siblings, with the defendant being the second of the siblings born. Her parents have never been involved with law enforcement interaction. She rates her childhood overall as good, with no history of abuse or neglect. She has never been married, not currently in a relationship, has three biological children, with Jason Burkhart being the father and being in foster care placement. Aurora, 6 years old, Lilith, 3, who's now deceased, and Isabel, 2. The defendant has had previous CPS involvement for Aurora, going to school and telling them that her dad beats her. But defendant stated it was a misunderstanding. And the second time CPS was involved was for their home being nasty. The defendant stated that she has two close friends, one she has contact with once every couple of days, and the other she has contact with once every 6 months. Neither friend has ever been in trouble or engaged in illegal criminal activity. She does not have otherwise acquaintances, stated she's never been affiliated with a gang. The defendant reported that she completed the 12th grade of education at West Union High School at the Ohio Valley Career and Technical Center in 2019. She reported that she was never expelled or suspended from school. She has the following additional education certifications. She has culinary certification and ServSafe. She does not have any military history. She rates her health as good, with some current medication prescribed for depression and anxiety. The prior substance abuse: the defendant reported that she tried alcohol once at the age of 16 and would have less than a cup of a mixed drink, but does not drink regularly, with the last time being December 31st of 2025. She reported that she did smoke marijuana daily from the age of 18 to the age of 25. She's never participated in substance abuse treatment. Her employment history is admirable. She has utilized her certification in culinary certification and ServSafe in her food and beverage training. She has been a manager at both McDonald's and KFC Taco Bell. At McDonald's between the periods of June 2023 and June 2025 for in essence a 2-year period. At KFC from August of 2018 until June of 2022, a 3.5-year stint, and then in between she worked with Subway as a line manager and cook. She reports currently having no monthly income or expenses, that when she was employed she could pay her bills. As most adults, she sometimes worried about her finances and struggled to make ends meet, but otherwise she was able to manage her debts. Recidivism, as to whether it appears based upon the assessments whether she's likely to recommit offenses, criminal offenses, it rates as low. The recidivism factors whether the offense was committed while on supervision or community control with any other courts or institutions. That does not apply. Whether she has a history of criminal convictions or juvenile delinquency adjudications, she does not have any prior felony criminal convictions. Whether she responded favorably to sanctions previously imposed in adult or juvenile court, there are no, because there's no prior record, there's no violations of the sentences in those cases, and she has not violated her bond. The next factor, whether she shows a pattern of drug and alcohol use related to the offense and doesn't acknowledge or refuses treatment. She does not show a pattern of drug use related to this offense. And lastly, the question of whether she has genuine remorse for her actions or for lack of actions, in a sense, in this case. They do say, the assessors do feel that she shows genuine remorse. She scored 10 or low on the Ohio Risk Assessment System, indicating a low risk of reoffending. The court notes that, and had earlier noted that it did receive and reviewed letters from a former Sunday school teacher of Ms. Hawkins, who has stayed involved in her life to the extent that she could, always showing, I guess, structure and mentorship, and also she indicates that Ms. Hawkins was always receptive and always kind and respectful to her children. There's also a second letter from the sister who sets forth her relationship with her sister. And then there is a Mr. Fox, or Jesse Fox, he or she, that gives a statement of credibility in regard to Ms. Hawkins. And then lastly, there was documentation received that during her 345 days incarceration that Ms. Hawkins has been a model prisoner for the Adams County Sheriff's Department, and that she's also seems to, it's joined in that there is remorse that's shown that she carries a folder with pictures of her children with her and often refers to them. With that said, the questions that I had about following the stipulation of sentence was why the third child was treated differently. The court has struggled with whether a 30-month sentence should be placed on each child. And again, I think I don't find that to be harsh when we look at the realities of this. And so that's the court's concern, and then also how the child ended up. And I realized sometimes children sleep naked, but there was just no guardrails there. And I ask in cases sometimes, would you go to the grocery store and sort through all the apple bin and pick out the bad apple and bring it home to your children? And mothers always say no. But you sorted through the apple bin and found this Brian Moser, bad apple. You knew he was a bad apple. You saw the change in his behavior, and you didn't put up any guardrails. And I struggle with that. Do you want to comment on that? You don't have to. Okay. Well, sometimes the court has to consider what the citizens and the community partners, what they have observed, what they know, what they have experienced, that they have interacted with Ms. Hawkins. This court, obviously, it's been very limited. The court has interacted with Ms. Hawkins. I do believe that Ms. Hawkins has great remorse for what occurred. There is a high likelihood there will never be recidivism in this case. Even in light of the court's concerns as to the variation in the agreement, the court does find comfort, especially in your in the very well written letter by your former Sunday school teacher that I thought she captured very well the person that we didn't know that she did know and did know. So it will be the order of the court that the court, with some hesitancy, but finalized, that after due consideration, the court finds the defendant is not amenable to available community control sanctions. The court does intend to follow the stipulated prison term, and it will be imposed that the defendant shall serve the stipulated prison term in count 3, of 30 months, a stipulated prison term in count 5 of 30 months, which shall be served consecutive to count 3, and a stipulated prison term in count 7 of 30 months, which shall be served concurrent to counts 3 and 5 for a total of 5 years incarceration in the Ohio Department of Rehabilitation and Corrections. Because multiple prison terms are being imposed on Ms. Hawkins for convictions of multiple offenses, the court may require that she serve them consecutively. Because the court finds that consecutive service is necessary to protect the public from future crime and/or to punish the offender, and that consecutive sentences are not disproportionate to the seriousness of the offender's conduct or the lack of conduct and to the danger that it poses to the public. And the court makes the finding that at least 2 of the multiple offenses, in this case 3 offenses, that 2 of the multiple offenses, at least 2 of them, were committed as part of 1 or more courses of conduct, and the harm caused by 2 or more of the multiple offenses so committed is so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct would adequately reflect the seriousness of the offender's conduct. The court finds that the defendant's placement or transfer into a transitional control program under 2967.26 while incarcerated, or her placement or transfer into an intensive program prison under 5120.032, both are hereby specifically reserved by this court for denial upon notification that the Ohio Department of Rehabilitation and Corrections desires consideration of the defendant for transitional control or for the intentional program prison. The court further notifies the defendant that post-release control is mandatory in this case upon your release from prison. And that will be up to 3 years maximum, but no less than 1 year. If, while under post-release control, you violate post-release control sanctions or any conditions imposed by the Adult Parole Authority or the Parole Board under Revised Code Section 2967.28, the Parole Board may impose more restrictive sanctions upon you: a prison term not to exceed 9 months for each violation, or a maximum cumulative prison term for all violations not to exceed 1/2 of the originally stated 5-year prison term as originally imposed. But if the violation of your post-release control is the commission of a new felony offense while under post-release control supervision, then you may receive a prison term of the greater of 1 year, or the time still remaining under your post-release control supervision up to that 3-year period on any or all of the 3 charges. And that may be required to be served in addition to or consecutive to any other prison sentence imposed for the new felony offense that would be committed that caused you to violate your post-release control. You're ordered to serve as part of this sentence any term of post-release control imposed by the Parole Board, as well as any prison term for violation of that post-release control. The defendant is therefore ordered conveyed to the custody of the Ohio Department of Rehabilitation and Corrections by the Adams County Sheriff's Department. She shall receive credit for 345 days as of today's date of June 17th, 2026. And as statutorily entitled, she'll also receive credit for any future custody days while she awaits transportation to the appropriate state penal institution. Ms. Hawkins, you're hereby notified that you may be eligible to earn days of credit under the circumstances specifically defined in Section 2967.193 of the Ohio Revised Code. You're notified that these days of credit are not going to be automatically awarded to you, but they must be earned in a manner specifically outlined under Section 2967.193. The court finds no beneficial matter of imposition of a fine upon Ms. Hawkins in this case, and so there will be no fine placed upon Ms. Hawkins. Any money that she may earn through state pay, I hope she sends that back for the benefit of her remaining 2 children. The defendant is ordered, though, to pay all court cost of the prosecution of this action for which execution is awarded and any fees permitted pursuant to Section 2929.18A4 of the Ohio Revised Code. The Department of Rehabilitation and Corrections is ordered to withhold funds in the appropriate amount from the defendant's account to pay these most limited financial sanctions. Under Section 2947.23A1A, if you fail to pay these limited financial sanctions or fail to make timely payments on these financial sanctions under a payment schedule approved by the court, then the court may order you to perform community service in an amount of not more than 40 hours per month until the judgment is paid in full or until the court is satisfied that you're in compliance with an approved payment schedule. Under Section 2947.23A1B, if the court does in fact order you to perform community service in lieu of or in exchange for the non-payment of the financial sanctions, then Ms. Hawkins, you will receive credit at a specified hourly credit rate. For every hour of community service you perform, it will reduce the judgment by that amount. The court does find that the defendant does have the past, present, and future earning income ability to satisfy these financial sanctions. Again, I noted the admirable work ethic of Ms. Hawkins in that she was a manager of 2 very active fast food branches in our community, and she's also served in capacity with a 3rd. She'll be able to earn state pay of $17 to $22 per month. And again, because of the limited financial sanctions, the court finds she has the past, present, and future earning income ability to satisfy these financial sanctions. There was not a cash bond posted in this case for the court's consideration of return to the surety for compliance or forfeiture due to noncompliance. The defendant shall be required to submit to DNA testing pursuant to Ohio Revised Code Section 2901.07. Before I give the appellate rights, I'll start with the state. Do you feel that the court has complied with the stipulated sentencing agreement as presented to this court?
Yes, Your Honor.
Defense counsel, same inquiry.
Yes, Your Honor.
Very well. Ms. Hawkins, do you believe the court has imposed the sentence that you had stipulated or agreed to with the state of Ohio.
Yes, Your Honor.
Ms. Hawkins, this is now a final appealable order. You have the right to appeal this court's decisions, but you must do so in a timely manner. You must do so within 30 days of today's date, for I intend to sign this judgment entry of sentence today. As a United States citizen, if you cannot afford the cost to file that appeal, then you have the right to file that appeal free of charge. If the court possesses documentation that you need to promote your appeal of this court's decisions, then upon your request, again, the court will provide those documents to you free of charge. If you cannot afford the cost to hire counsel to represent you effectively, as the court firmly believes that both Ms. Carrington and Mr. Walker have done in this underlying matter, then upon your request, the court shall forthwith or right away appoint an attorney to represent you. But you will be required, Ms. Hawkins, to pay a $25 energy counsel fee fund. Ms. Hawkins, I stress to you and I emphasize to you, you must file that appeal within 30 days of today's date. Ms. Hawkins, do you feel you understand your appellate rights?
Yes, Your Honor.
Ms. Hawkins, did you understand that you must file that appeal within 30 days of today's date?
Yes, Your Honor.
Do you have any questions about your sentence or your appellate rights?
No, Your Honor.
State of Ohio, do you have anything additional or objections you'd like to have noted at this time?
No, Your Honor.
Ms. Carrington and or Mr. Walker, anything additional or objections you'd like to have noted at this time?
No, Your Honor, thank you.
Ms. Hawkins, is there anything else you would like your counsel to bring to the court's attention before we conclude today's hearing?
No, Your Honor.
Ms. Hawkins, I always appreciate the courtesy that you have always extended to the court and the court staff throughout these proceedings, and we thank you for that courtesy extended. We're off record.